Hello and welcome to the latest edition of the Number 8 Chambers Immigration Conversation series. I'm Emma Rutherford, a member of the immigration team, and I'm joined today by Stephen Vokes, who's head of the immigration team. And today we're going to talk about deportation cases, and specifically the unduly harsh test and very compelling circumstances tests, which arise in Article 8 cases involving family members. The purpose of this is not to give legal advice, it's simply two members of Chambers having a discussion about legal issues that arise and giving our thoughts about that, but make it very clear that this isn't legal advice that we're providing today. Just to maybe set the background a little bit about the deportation regime, as I'm sure those watching know, that if the Secretary of State decides to make a deportation order against somebody, and of course if you're sentenced to 12 months or more imprisonment, she's obliged to, unless one of the exceptions applies under the 2007 Act. One of those exceptions is of course a breach of human rights, and the exception frequently relied on is a right to family life, and saying deportation will breach my right to family life. In 2012, the immigration rules were amended to include tests that needed to be applied. And when looking at family members who are sent, in cases where the person is sentenced to between 1 year and 4 years imprisonment, or I should say less than 4 years imprisonment, because of course there's use of deportation as well. If there is a qualifying relationship with either a child or a partner, then of course the test that needs to be met is that it is unduly harsh for that settled family member, or British citizen family member, to either relocate with the person being deported or to remain in the UK without them. And of course, then if you get over 4 years, the test has been set down as being very compelling circumstances. We did in 2014, of course, have the 2002 Act amended to introduce Section 117C. And that, of course, again, it brings into force the unduly harsh test, where you've got a qualifying child or qualifying partner. Slightly different wording to the rules, but ultimately the question is deportation unduly harsh? Today, Stephen and I, as I say, are going to talk a little bit about the unduly harsh test, what's been said by the courts about that, and then moving on to the very compelling circumstances test. Just to set a little bit of background in relation to the beginning of the unduly harsh test, of course, we finally had some clarity, if you can call it that, from the Supreme Court in the case of KO in 2018, in which they explained what they understood unduly harsh to mean. And they said, well, it means more than reasonableness. It's a higher test than that. You're looking for something specific. It makes this case in the situation where it is unduly harsh for this family to be separated or for them to relocate, and made it very clear that it's a higher test that needs to be considered by the tribunal. Now, we've had some recent case law, haven't we, Stephen, in the Court of Appeal and the Upper Tribunal, setting out and applying the test in KO. I don't know what your thoughts are in relation to that.
Yes, we certainly have. Probably the best roundup is in an Upper Tribunal case called Imran, bracket section 117C5, semicolon, children, and comma, unduly harsh, 2020 UKUT 83, IAC. And this was a panel with a a very clever High Court judge on it, called Martin Chamberlain, and Declan O'Callaghan from the Upper Tribunal. And what they did was they went through the recent case law in PG Jamaica, that's 2019 EWCA Civ 1213, and KF Nigeria, 2019 ECCA Civ 2051. And with reference to those cases, they dissected what unduly harsh means. And essentially, and they're dealing with children, because a lot of these cases involve children. And they said, well, look, separating a parent from a child would be traumatic. However, that doesn't mean to say it's unduly harsh, because the test needs something more than what they regard as the commonplace affection between a parent and a child and the bond being broken because the parent has to be removed from the United Kingdom. So that what they were actually looking for, and indeed the fact that, for instance, a child might need extra help at school to cope with the situation of the parent going, wasn't enough. And of course, the difficulty is, as KO Nigeria pointed out, is you're not just looking for harshness here, you're looking something that goes beyond it, unduly harsh. Mr. Justice Chamberlain did come out with a suggestion. He said he wasn't going to be prescriptive, but for example, if there was evidence of psychiatric injury to the child because father was going to be removed, that's, I think it's paragraph 29, that might be sufficient to show that in fact it would be, you may approach the unduly harsh threshold. But really, the tribunal, and indeed the Court of Appeal, which has dealt with a lot of these cases, have gone out of their way to emphasize the legal test involved and stress that it's not just for the immigration judiciary to have sympathy. The Court of Appeal, indeed, in both KF and PG, had sympathy for the children involved, but of course they went for the strict statutory construction. And as a result, I find it a difficult hurdle to overcome. Now, I don't know what your experience is, Emma, but certainly my experience is that in essence, you may have a distressing family situation, but really it doesn't meet the undue harshness test.
Yes, I mean, I think judges for some time, that the direction of travel in both the Court of Appeal and the Upper Tribunal has been that it's a very high test to be met. It goes way beyond that you would have in an ordinary immigration case, and reasonableness. You really do need something outstanding in order to persuade a judge that there is in fact undue harshness, either through separation or through relocation, or both, because it does of course need to be both, in order to establish that the test is met. It does seem that the Court of Appeal, they very much worked on the basis that there's no spectrum in terms of distress that be caused to a child in terms of the ordinary separation. They don't seem to reflect the fact that different circumstances may mean that a child who may have a limited relationship with a parent is likely to be less affected than one that has a really close relationship. And they seem to work on the basis that all children have a really close relationship. And they don't seem to give any consideration to whether there's a spectrum. They just work on that basis that, well, even if there's a really close relationship, that's not going to be enough. You need something much more in terms of impact than there would be in those circumstances.
Yes, just on that last point, that's an interesting, subtle point you make. But the interesting thing is, in KF Nigeria, the judge, the first tier tribunal judge, had found that the child and the parent had a very close bond. And essentially, the Court of Appeal found that that wasn't essentially sufficient. And they seemed to proceed on the basis that all children have close bonds with their parents, which of course is not necessarily true. But I only throw that in because they actually felt that the closeness of the bond, again, wasn't sufficient to come near, really, the standards of undue harshness.
Yes, it's an interesting point. I think in KF the child was only 3, wasn't he? Was it PG where there was the very close bond, I think, whereas in
KF, right, I've got it the wrong way around.
I've got that the wrong way around. I think KF was where the judge accepted that there was a limited relationship, I think, in KF, and that there was a but substantial family connections, but was very concerned about the ability of the child to develop a close bond with father, and accepted that that would be disrupted on removal. But I think, you know, both cases point in exactly the same direction, that, you know, a close bond between parent and child is not going to be sufficient. So you have the position that a child who maybe has a limited relationship with a parent because they have limited contact, but have some contact and benefit from that, who are going to be distressed, but their day-to-day life isn't going to change. Their position is almost analogous with a child who lives with a parent who's really close to them, maybe has that parent as primary carer, but they're all assessed against the same standard of what's unduly harsh. There's no consideration that it might be much harder for that second child with the close relationship than it would be for the child with a more limited relationship with a parent, albeit it prevents their relationship developing. But they're harsh cases.
Yeah, I mean, the interesting point, I suppose, is this, that if I'm right on the matter, that one can be in a situation where one doesn't qualify for automatic deportation under the 2007 Act, but the Secretary of State in the immigration rules in paragraph 398 deems a single offence sufficiently serious. I'm talking about somebody, for instance, gets 6 or 7 months, therefore doesn't fall under the automatic deportation provisions, to actually deems the case sufficiently serious to be actually come under the deportation rules, and moreover under the unduly harsh criteria, which is again set out in 398 and 399. The interesting point, of course, is that's not reflected in section 117C, but it means that essentially there is a discretion on the part of the Secretary of State to label an offence as essentially sufficiently serious that it merits a deportation order. One supposes the tribunal would actually have to take a view on whether, in fact, it was sufficiently serious to lead to a deportation order. But I merely flag up, in that case, you would have the same hurdles then to qualify under the immigration rules. That is the undue harshness test.
Yes, you would. And of course, that test also applies to those who are deemed to be persistent offenders. So although it might be relatively low level offending, repeated offending, although not getting anywhere near the 12 months in one single sentence, would lead again to the potential for the Secretary of State to make that deportation order and having to meet the undue harshness test.
Yes, I mean, the interesting thing is, of course, the definition of foreign criminal in section 117C wouldn't apply, because it's someone who, as we know, someone that's sentenced to 12 months or more, wouldn't actually apply to somebody whose basically offence is so serious in the eyes of the Secretary of State. But that might need to be explored more by the Court of Appeal. But of course, that one still is in breach of the immigration rules if, in fact, the undue harshness test applies.
Well, yes, and of course, as I said in the introduction, we had, of course, the amendment to the immigration rules in July 2012, and then we had the statutory provisions come in, I think it was July 2014, where the primary legislation was amended. But prior to that, the undue harshness test was being applied, but Parliament obviously felt that primary legislation was required over and above the immigration rules.
Yeah, and then, of course, if you're dealing with an offender, I suppose, who gets more than 4 years imprisonment, we then go on to very compelling circumstances over and above undue harshness. The only point is, and I'll set the stall out here, is, of course, the focus then is not just on the question of children or partner about whether it will be unduly harsh. But following NA Pakistan, it means we look at the whole situation. The problem is, of course, is you've got a test which can hardly be more trenchant, very compelling circumstances.
No, and the senior courts have made it very clear repeatedly that it's a very high bar indeed to be passed, an extremely high bar. I think the phrase that they've used. A recent case last year, an immigration case of RA in the Upper Tribunal, 2019's RA Iraq 2019. That again they emphasise the very high threshold that is to be applied there. Although you can bring in factors that are not specifically listed under the immigration rules, you can look at things such as length of residence, extent of integration into the UK, rehabilitation arguably could be brought in, but of course RA questions how far that assists somebody. A whole range of factors, and it's not limited, can be considered at this point, but the test that you have to meet is exceedingly high. This goes above the unduly harsh test. And of course, it applies to those who can't meet the unduly harsh test, who got less than 4 years imprisonment. This is their final fallback position. So,
yeah, I mean, a couple of points arise out of that. I have to say that in my experience, unless you get a scenario such as, and a dramatic one such as one parent to be removed, and the other parent is, let's say, I don't know, stage 4 cancer. So you have children who would be left with no parent in a traumatic situation where one of the parents was literally dying on them. Something like that, sketch out that kind of scenario, might actually lead to a finding of very compelling circumstances. I do that because it's interesting to have some practicality involved. And I just wanted to comment on RA and this question of rehabilitation, because essentially it seems to me that this is actually still rather a hot topic. RA itself, at paragraphs 31 to 33, dealt with this question of rehabilitation, and building on a case called SC Zimbabwe in the Court of Appeal, 2014, EWCA Civ 256, it's paragraphs 48 to 56, I think, said, well, basically, a rehabilitation doesn't have any role to play because one would expect people to behave properly. However, what wasn't cited in RA was a previous presidential decision in MK, Section 55, Tribunal Options, Sierra Leone, 2015, paragraph 42, Roman 6, where the then president actually places weight on rehabilitation as part of the factors one can take into account when we're looking at very compelling circumstances. And I might add, in LG Columbia, which is again a Court of Appeal case, 2018, 2018 EWCA Civ 1225, paragraphs 27 to 29. Again, a differently constituted court from that in SE Zimbabwe found rehabilitation could play a role. So it seems to me that this area isn't closed. Of course, at the tribunal in RA, the president said did cite LG Columbia, otherwise known as Garzon, and said, oh, well, I'm not going to close the door on this, but seemed to indicate that LG Columbia was a rather exception to the rule. Yet, if one reads the judgment in that case, the Court of Appeal certainly didn't think so. So it seems to me that this question of rehabilitation in a very compelling circumstances case is open to some interpretation at the moment. Although, as you say, very compelling circumstances are what they say they are.
Yeah, but I suppose if rehabilitation becomes a factor that is one that can be considered, it may tip a difficult case over the edge of the balance that needs to be met to show that it's very compelling circumstances. Because the case law has always emphasised, when looking at very compelling circumstances, that it is a case of making a holistic assessment, the Hesham-Ali balance sheet approach, if you like, assessing all the relevant factors against that public interest to see whether there are very compelling circumstances in this case over and above those set out in paragraphs 399 and in the context of private life 399A.
Yes, I think that what you say has is absolutely correct. The emphasis is holistic factors in the round, and the fact that quite often in my experience, you find that in very compelling circumstances, the first tier judiciary just apply an unduly harsh test and sort of say, well, there's nothing beyond that, and their focus is not on looking at all the circumstances in the round, but rather, for instance, on the effect on the children and so forth, without looking at the offence, without actually looking at, as we've just said, rehabilitation and so forth.
And of course, factors such as integration. You may well have someone who's a lawful migrant and been here for a very long time. That mightn't have been sufficient to succeed under private life, but becomes a factor that can be balanced within a holistic assessment, along with the effect on children, rehabilitation, the offence itself.
Yeah, in fact, to be blunt, one can throw the kitchen sink in and include worth, one supposes, worth to society and so forth. So, although, I mean, I conclude on that although the test is very, very high, at least under very compelling circumstances, you do have an opportunity to put the whole of your client's life before the tribunal.
Yes.
Which, of course, doesn't apply with undue harshness. And on that note...
Yes, it's been nice talking to you today, Stephen.
And you. Thank you very much, Emma.
Take care.
Okay.